Karan bhai, can we start? Good evening, everyone. Jai Mata Di to everyone. Happy Navratri to everyone. Best wishes for Dashera. We are not taking much of the time except to state that thankful to Dharan Bhai Gandhi for taking this particular session on a timely basis at very short notice. He has agreed to be to lead this session today. So I will not take much of the time between you all and the speaker. Over to Chirag for further proceedings.
Uh, it's an honor to introduce Dharan. As such, he wouldn't require much of introduction because he is a well-known person delivering talks and lectures and spreading knowledge everywhere. However, I'll complete with the formality and try to quickly summarize what exactly Dharan does in his profession. So he practices as an advocate and he regularly appears before Supreme Court, Bombay High Court, other high courts, income tax appellate tribunals, CIT appeals, and DRB. He specializes basically into corporate tax, international tax, transfer pricing, and GST litigation. He has held various positions in CTC itself. He had been the chairman of the Corporate and Allied Law Committee for the year 2020 and 21. He was chairman of the Direct Tax Committee. He has been the convener of Direct Tax Committee of CTC from 2017 18 till 2019-20. He's co-author of various books, naming a few: Interpretation of Statute, which is a treatise on Vivad se Vishwas, and Section 56 to 10. Without taking much ado, I would like to hand over the dais to Dharan and would, want to eagerly wait and learn across the analysis that he has wonderfully done. Thanks, Dharan. Thanks.
Yeah. So thank you so much for a warm introduction, and thank you so much, Chamber of Tax Consultants, for inviting me to share my thoughts. Too premature to share thoughts on the complete or holistic analysis of this judgment because we are still waiting for many clarifications which are likely to come because the judgment has kept many things open-ended, and we expect the department to come out with a clarification. Second point, Mr. Venkatraman, the learned ASG, who had appeared in this matter for the department and was successfully argued for the department, was scheduled to have a talk at some other forum, but his talk has been postponed, and therefore I don't have the benefit of his view on the judgment. Though I have had a discussion with various other seniors and various other counsels who had appeared before the court in respect of the analysis of the judgment. So, a lot of ifs and buts. We have to wait for the clarification, but I'll share my thoughts to the extent possible. Yeah, is the screen available?
Yes, we can.
Yes. So I'll just take 5 minutes to give a background, and then I'll jump to the judgment of Ashish Agarwal, the instructions, and the judgment of Rajiv Bansal. First and foremost, what is this controversy? This controversy arose because of the confusion which was created during the COVID pandemic. Time limits to issue notices were extended from time to time. But it is not as simple as extension of a time limit, because this time limit extension was challenged or by way of was hindered by an amendment brought in by Finance Act 2021, which brought in completely new time limits, new jurisdictional requirements, new approving authorities, etc. So really the controversy is the time limit extension of TOLA versus the amendment brought in by Finance Act 2021, and which will prevail over what is really the controversy. Now, TOLA extends the time limit to issue notices till 31st March 21. So, up to 20th March 2020 till 31st March 2021, if there was something which was getting time barred insofar as reassessment notice is issued, then they could have issued notice till 31st March 21. The department came out with a notification number 20 of 2021, wherein they extended a time limit till 30th April 21. And then they came out with notification number 38 of 2021, whereby they again extended a time limit to issue notice under 148 till 30th June 21. Now, both these notification extended the time limit to issue notice under 148 under the old law. So this is insofar as TOLA is concerned. At the same time, Finance Act 2021 was enacted. Finance Bill was laid down before the Parliament. Finance Act was enacted, which brought in a complete overhaul of reassessment proceeding from 1421. New sections 147 to 151 were introduced, including a jurisdictional section of 148A. Now, there were new time limits and new approving authorities which were made available from 1421. Though from 1421 the new law was applicable, the notification issued under TOLA stated that up to 30th June 21, you please issue notice under the old law. Relying on such notifications issued under TOLA, the department issued notices from 1st April 21 till 30th June 21 under the old law and not following the new law, because under the old law, you have to first issue a 148 notice. Thereafter, I ask for reasons as per GK and drive shaft and then order disposing objections. Under the old law, this process of issuing show cause and giving reasons is preceding the issue of notice under 148. So first you have to follow the process of 148A, and then if you are satisfied, you issue a 148 notice. Since in all these notices, new law was not followed, the same were challenged before various high courts. Various high court took a view that after 1421 new law applies, all notices bad in law. Matter went to the Supreme Court in the case of Union of India Ashish Agarwal 444 ITR 1. Supreme Court construed the controversy from a holistic perspective. They firstly agreed with the views of the High Court that from 1421 new law will apply and not the old law, and therefore all notices issued by the department cannot survive in the existing form. At the same time, they also realized, but the department proceeded on a bona fide belief that after 1st April 21 till 30th June 21, because of TOLA and the notification, we could have issued notices under the old act. To balance the rights of both the parties, the Supreme Court invoked Article 142 of the Constitution of India, which is a discretionary power given to Supreme Court to go beyond the statutory provisions to do justice. And they issued a slew of directions. The first direction issued was all the notices issued under 148 between 1st April 21 to 30th June 21 were deemed to be show cause notices under section 148 AB of the judgment of Supreme Court of the 4th May 2022. They asked the department to provide information and material to the assessee within 30 days from 4th May 2022. The assessee was given 2 weeks time to file reply. On receipt of material and information, requirement for conducting inquiry was done away with, and AO was thereafter supposed to pass order under section 148 AD of the Act and issue 148 notice. And all defenses of both the parties under 149 and under new law were kept open. And this judgment, Supreme Court applied for on pan-India basis. It applied to the matters before Supreme Court. It applied to cases where the high courts have passed the order, but department is yet to file SLP. And it also applied to cases where the matters were pending before the high courts and high court had not disposed of the matters. So these were some of the directions issued. Pursuant to this direction, since the department got a new lease of life, they came out with instruction number 1 of 2022 to give effect to Supreme Court order. And they issued a slew of directions to be followed by revenue while issuing notices and by following the judgment of Supreme Court. Firstly, they stated that this judgment will apply to all cases, irrespective of fact whether an assessee has challenged the notice before Supreme Court or High Court in a writ jurisdiction or not. So, irrespective of the fact whether you were before the High Court, the judgment would apply. 2, they stated that as per the Supreme Court judgment and as per the taxation TOLA, the notices will travel back in time. Accordingly, it concluded that EY 1314, 1415, and 1516 can be reopened under 149 1B because it is beyond 3 years. Condition of 149 1B has to be fulfilled. Approval under 151 2 has to be taken. So if it is less than 50 lakhs, they have to drop it. And insofar as EY 16, 17, and 17, 18 are concerned, it is considered to be within 3 years, and therefore it can be issued under 149 1A and approval under 151 1. Then they lay down the procedure. Material has to be provided by 2nd June 2022, 2 weeks time to file reply, and if extension is sought, then the extension has to be granted. Now, Post the judgment of Supreme Court, post the instruction of the Supreme Court, matters were again taken before the High Courts on various grounds. There were 5 assessment years involved: AY 13-14, 14-15, 15-16, 16-17, and 17. Insofar as AY 13-14, 14-15, and 15-16 are concerned, we challenge those assessment years on the ground that they are barred by limitation in terms of first proviso to section 149(1) of the income tax. First proviso states that a notice under 149(1)(b) can be issued up to 10 years, but if at a particular point of time notice cannot be issued under the old law, old 149(1)(b), then notice cannot be issued under the new law, new 149. Which means under the old law, time limit is 6 years. Therefore, notice even under the new law has to be issued within 6 years. And this first proviso, which was in the nature of a sunset clause, or it was not giving retrospective effect to 149(1)(b), was applicable up to AY 21-22. So up to AY 21-22, they could have issued reopening notices only up to 6 years and not up to 10 years. Now AY 13-14, 6 years expired on 31st March 20. AY 14-15, 6 years expired on 31st March 21. AY 15-16, 6 years expired on 31st March 22. And all the notices after Ashish Agarwal's judgment were issued sometimes in July 22 to September 22. And therefore, they were challenged on the ground they are barred by limitation. AY 16-17 and 17-18 were challenged on 2 grounds. Firstly, the notices have been issued beyond 3 years from the end of the relevant assessment year. And therefore, approval has to be of the authority prescribed under 151 clause 2. And 2, since they are issued beyond 3 years, therefore conditions of 149(1)(b) have to be fulfilled, which is the income escaping assessment should be more than 50 lakhs. Now matters travel to the various high courts. Insofar as AY 13-14 and 14-15 are concerned, Allahabad, Gujarat, Bombay, Calcutta were in favor of the assessee on the ground of limitation. Delhi High Court, Touchstone and Salil Gulati were against the assessee on the ground of limitation. AY 15-16, Bombay High Court, Hexaware was in favor of the assessee. At the same time, even Rajiv Bansal dealt with AY 15-16 was in favor of the assessee. AY 16-17, 17-18, Bombay High Court, Siemens was in favor of the assessee on the ground of approval. Delhi High Court, Twilight Infrastructure was in favor of the assessee on the ground of approval. Whereas Delhi High Court, Ganesh Das Khanna was in favor of the assessee on the ground that the income escaping assessment is less than 50 lakhs, therefore it is time barred. Some of the matters travel to Supreme Court. So these are the findings of the High Court. The finding of the High Court insofar as AY 13-14 and 14-15 is concerned is as follows. TOLA will not apply to new law after 1/4/21 because TOLA applies to something which has to be done till 31st March 21. New law comes into effect from 1/4/21 and therefore TOLA will not have any implication. 2, in any case, even if TOLA applies, notifications which extend the time limit from 31st March 21 to 30th June 21, they are a delegated piece of legislation. Therefore, they cannot override the amendments by Finance Act 21. This was the second finding. Since TOLA does not apply, notification does not apply. Therefore, the time limit under the old law will be 31st March 20 and 31st March 21. And all the notices issued under July 22 till September 22 are barred by. So there is no dispute that if TOLA does not apply, whatever contentions the assessees have raised are valid in the eyes of law, is what even the Supreme Court records. Insofar as AY 15-16 is concerned, again, the finding that TOLA does not apply to new law and the notification cannot override the amendments by Finance Act 2021 were accepted. Apart therefrom, the Bombay High Court held that TOLA does not apply to AY 15-16 and 16 and subsequent assessment years because these assessment years are not getting time. As a result, there is no time limit. As per the first proviso, the last day to issue notice is 31st March 22. Since the notices were issued between July 22 till September 22, all are barred by limitation. So this was the Bombay High Court ruling in Hexaware. AY 16-17, 17-18, again the same finding. TOLA does not apply to new law. Notifications cannot override the Finance Act, and the TOLA in any case does not apply to 15-16 and subsequent assessment years. One more important finding given by the High Court was that TOLA does not apply to approvals under 151. Under 151, there is no time limit prescribed to grant approval. It is an open-ended provision. Since there is no time barring date, therefore TOLA cannot apply to such provision. And therefore, since the approval is taken off an incorrect authority, it is bad. At the same time, the Delhi High Court in twilight held that all these notices are issued beyond 3 years. Since the income escaping assessment is less than 50 lakhs, the cases are time barred. So these were the findings of the High Courts on these 5 years. Now let us come to the judgment of Supreme Court in the case of Union of India versus Rajiv Bansal. The judgment is dated 3rd October 2024. There are various findings given by Supreme Court on the issue of limitation and approval. There are various other findings given by Supreme Court on other issues which I will be dealing with, which are also equally crucial. And then we'll find out what is the impact on our cases. Yes. Firstly, the first argument taken by the assessees before the Supreme Court was that Ashish Agarwal will apply only in cases which were challenged before the Bombay High Court or other high courts, whether or not taken before Supreme Court. So if an assessee, there were 90,000 notices, only 9,000 writ petitions were filed. 81,000 cases, no writ petitions were filed. So if an assessee had not challenged the notice issued between 1st April 21 till 30th June 21 before the High Court in a writ jurisdiction, Ashish Agarwal had no implication. What did the Supreme Court hold? Supreme Court's finding is in Part F, Para 89 to 93. And in Para 91, the Supreme Court holds that scope of directions in Ashish Agarwal applied pan-India, including all the 90,000 reassessment notices. So A, it applies to every notice. Para 92, operation of the directions cannot be limited to the above 3 categories, especially when the court has specifically held that present operations order shall be applicable pan-India. The 3 categories were A, cases which were challenged before Supreme Court; B, cases where High Court has disposed of the writ petitions, but the SLP is yet to be filed; and C, cases where writ petitions are pending. So court says it is not only applicable to these 3 category of cases, but to all cases. In effect, Supreme Court has held that Ashish Agarwal will apply to all 90,000 notices. Now there is one issue which crops up here. Say for example, notice is issued between 1st April 21 to 30th June 21. And it is already disposed of by way of an assessment order before the Ashish Agarwal judgment comes in. So we have seen few cases, not many cases, but few cases where the notices issued between 1st April 21 till 30th June 21 have already been disposed of by way of an assessment order. Say for example, in February 22 or March 22. Then the assessees had not challenged either making an addition or not making an addition, clean order or an order where demand has been raised. If the notice is already disposed of by way of an assessment order, still can the judgment in case of Ashish Agarwal apply or not? In this regard, there are 2 Delhi High Court judgments in favor of the assessee, Anindita Sengupta and Jaswant Singh Juneja. In fact, this issue had also come up before the Bombay High Court, and the Bombay High Court in one of the case had asked the department to withdraw the notice once the assessment order has already been passed. So in these cases, the courts have held that once the assessment order is passed, 148 notices already disposed of by an assessment order, and therefore Ashish Agarwal will not apply. Now, what will be the impact of the judgment of the Supreme Court and Rajiv Bansal in all these cases? The Supreme Court has held that the judgment of Ashish Agarwal making its order applicable pan-India is by invoking its discretionary power under Article 142. Since it's invoked under Article 142, therefore, probably one has to take a view that it will apply to all 90,000 notices, irrespective of the fact whether whether the assessment order is passed or not passed. Now, naturally, the Supreme Court was not seized with the controversy whether what will happen to cases where assessment order has been passed. Therefore, one can argue that the judgment in case of Rajiv Bansal has to be read in the context. It was not dealing with an issue where assessment order is already passed. It should not apply to those cases where assessment order is already passed. Having said that, we'll come to know the fate of those cases where assessment order is already passed before the Ashish Agarwal judgment only when these 2 judgments of Delhi High Court are challenged before the Supreme Court. Till such time, there will be some limbo. Both views are possible till the time Supreme Court disposes of the SLP against these judgments. Now, the second controversy which was raised before the Supreme Court is this. When the Finance Act 2021 brought in section 148, it stated that 148 AA has to be issued with the prior approval, inquiry notice. AB show cause has to be issued with the prior approval of the specified authority, and AD order has to be passed with the prior approval, as well as the notice under 148 has to be issued after with the prior approval. When the Supreme Court converted the old 148 notice into a 148 AB notice, we argued that though you are converting it into a 148 AB notice, these notices are issued with the approval of some authorities, but those authorities are not the approving authorities under the new law. So under the old law, if it is issued within 4 years, Joint Commissioner, Additional Commissioner. If it is issued after 4 years, up to 6 years, Principal Commissioner or Commissioner. Under the new law, if it is issued within 3 years, Principal Commissioner or Commissioner. And if it is issued beyond 3 years, then Principal Chief Commissioner or Chief Commissioner. All 148 notices were issued under the old law under a bona fide mistake. So they were issued after taking approval of old authorities. Those authorities were not correct authorities under the new law. As a result, all 148 notices, which were deemed to be 148 AB notices, could have been struck down on the ground that though you have deemed it to be a 148 AB notice, but the approval part has not been dispensed with, and therefore all these notices have been issued with the approval of a wrong authority, bad in. Supreme Court categorically says 148 AA requirement of making inquiry with prior approval is dispensed with. But there was no finding of the Supreme Court that even the 148 AB prior approval is dispensed with. So this was one of the argument raised that the Supreme Court has not categorically held that the approval for 148 AB is to be dispensed with, and therefore since the notices though termed as 148 AB notice approved by wrong authority, it is bad in law. Supreme Court has dealt with this contention in para 80. It has held that where the court deemed the 148 notice under old regime as 148 AB notices, it impliedly waived the requirement of obtaining prior approval from specified authorities under section 151 for section 148 AB notice. This had to be the natural finding of the Supreme Court, because if this view is taken that no, you still have to come out with a proper approval. Once the notices were issued under the old law, it was impossible to comply with this requirement. And therefore, if this requirement was still enforced, then the judgment of Ashish Agarwal lost the entire purpose, and therefore this finding was inevitable. Now coming to AY 1617 first, and that too on the approval issue. Now here the findings of the Supreme Court are not very clear, but they are somewhat clear, and I will explain this how. The question before the Supreme Court, as phrased in para 16 and as phrased in para 18b, I have brought out before in the presentation. Firstly, notices under 148 of the new regime were issued to the assessees by assessing officers between July and September 22 for 5 years, and these 5 years include 16, 17 and 17. These notices were challenged before several high courts. High courts declared the notices to be invalid on the ground that they were issued without the appropriate sanction of specified authority. And also see para 18b, whether the reassessment notices issued under section 148 of the new regime between July and September 2022 are valid or not. Based on these two paras, what I want to canvass is that Supreme Court was seized with the issue whether notices under 148 issued between July to September 2022, whether they were valid or not, on the ground that it has been issued without the appropriate sanction of specified authority for the assessment year 16, 17 and 17, 18. This was held by the Bombay High Court in Siemens and the Delhi High Court in Twilight. Both the judgments were before the Supreme Court. Different findings have been given by Supreme Court, which I have brought out in a nutshell. In para 74, Supreme Court says they have reproduced a table which are the authorities, and then they say that the specified authority to grant approval is directly correlated to the time when the notice is issued. So here they say you have to see when the notice is issued and the authority who can grant approval at that point of time. Then para 76 says grant of sanction by appropriate authority is a precondition for assessing officer to assume jurisdiction. So if appropriate authority has not granted sanction, then the notices are without jurisdiction. Para 76 again says the 151 of the new regime does not prescribe a time limit within which a specified authority has to grant sanction. Rather, it links up the time limit with the jurisdiction of the authority to grant sanction. So they say there is no time limit prescribed to grant sanction, but it is linked with the jurisdiction of the authority to grant sanction. Now, the crucial findings of the Supreme Court are in para 77, 78 and para 114D. The test to determine whether TOLA will apply to section 154 of the new regime is this. If the time limit of 3 years from the end of the assessment year falls between 20th March 20 and 31st March 21, then the specified authority under 151 has an extended time till 30th June 2021 to grant approval. Please see para 78. For example, the 3 years time limit for assessment year 1780 falls for completion on 31st March 21. It falls during the period of 20th March 20 and 31st March 21, contemplated under section 31 of TOLA. Resultantly, the authority specified under section 151(1) of the new regime can grant sanction till 30th June 21. And then para 114D. TOLA will extend the time limit for grant of sanction by authority specified under section 151. Test to determine whether TOLA will apply to section 151 of the new regime is this. If the time limit of 3 years from the end of the assessment year falls between 20th March 20 and 31st March 21, then the specified authority under 151 has extended time till 30th June 21 to grant approval. So having read the two slides, A, issue before the court was who has to grant approval while issuing notice under 148 when such notices are issued pursuant to Ashish Agrawal in July to September 2022. What has the court held? Authority as specified under 151(1), which is principal commissioner and commissioner, they get an extended time only till 30th June 21. Impliedly, not directly, but impliedly, after 30th June 21, if the notices are issued under 148, then approving authority is the authority specified in 151(2), which is the principal chief commissioner or chief commissioner. As a result, impliedly, judgment of Bombay High Court in Siemens, judgment of Delhi High Court in Twilight have been affirmed by Supreme Court in as much as notices issued in July 2022 till September 2022 have been issued with the approval of authority specified in 151(1), who could have granted approval only till 30th June 21. He could not have granted approval after 30th June 21. Since the notices between July 22 to September 22 have been issued with the prior approval of authority specified in 151(1), all notices are issued with the approval of an incorrect authority and therefore bad in law. Probably, therefore, it appears that 1617 and 1718, the approval has been taken of a wrong authority and therefore it is bad in law. Now, I'll come to 1617 limitation issue after I have finished the limitation issue of AY 1314. Probably, if my view that AY 1617 and 1718 approval is a wrong authority, Supreme Court has held so, then there is no need to go into the limitation issue. Still, we'll go into the limitation issue after we finish the discussion on the AY 1314 and 1415 time barring issue. The other aspect which the Supreme Court has dealt with is first proviso to section 149. What does the first proviso say? First proviso says that at any point of time, if a notice under 148 cannot be issued under the old erstwhile 149(1)(b), then at that point of time, you cannot issue notice under the new law. Now, why this finding is crucial? Because before the Bombay High Court in Hexaware's case, the department had taken the argument that first proviso will only apply to notices which could have been issued before 1421, that is to AY 1314, 1415 and prior years. It cannot apply to AY 1516 onwards, and for AY 1516 and subsequent years, time limit of 10 years would apply. And therefore, AY 1516, when it is issued in July 22 or September 22, notices are very well within the time limit prescribed. So the department argued before the Bombay High Court that first proviso which prescribes that one cannot issue a notice under the new law if it is time barred under the old law at that point of time, will apply only to the notices which could have been issued prior to 1421. Of course, the Bombay High Court held that first proviso applies to assessment year 21-22 and prior assessment years, and it is in the nature of a sunset provision, and up to 21-22 all notices can be issued only up to 6 years. This has been confirmed by Supreme Court in various paragraphs. Firstly, para 10(3), first proviso to section 149 prohibits the issuance of reassessment notice under the new regime if such notices have become time barred under the old regime. ASG in his submission in para 19B conceded this point. ASG argued that section 149 of the new regime provides 3 crucial benefits to the assessee. 4-year has been reduced to 3 years. First proviso to section 149 ensures that reassessment for previous assessment years cannot be undertaken beyond 6 years, and the monetary limit of course 50 lakhs. And then the court held in para 46, the ingredients of the proviso could be broken down for analysis as under. And now, please see, no notice under 148 of the new regime can be issued at any time for an assessment year beginning on or before 1st April 21. If it is barred at that time when the notice is sought to be issued because of the time limit specified under provisions of 149(1)(b) of the original old regime. Thus, a notice could be issued under section 148 of the new regime for assessment year 21-22 and before only if time limit for issuance of such notice continued to exist under section 149(1)(b) of the old regime. And similar findings are given in para 49. In short, up to AY 21-22, despite 149(1)(b), because of first proviso to 149(1), notice can be issued only up to 6 assessment years. Therefore, the judgment of Hexaware has been approved to this extent. Up to AY 21-22, it can be reopened only till 6 years. Of course, now the Finance Act number 2 of 2024 has reduced its time limit to 5 years, and therefore this argument would no longer be effective for reassessments after today, but it will naturally be effective for the earlier assessment years. Now, the Supreme Court thereafter gave finding on the issues of TOLA vis-a-vis Finance Act 21 vis-a-vis Ashish Agarwal. So, the argument of the assessees were TOLA will not apply to Finance Act 21. TOLA applies to something which can be done till 31st March 21, and Finance Act 21 applies and something can be done under Finance Act 2021 only after 1/4/21, and therefore TOLA will not apply to Finance Act 2021. To this extent, the Supreme Court has given a finding that TOLA under TOLA, Section 2 defines specified act, and Income Tax Act is one of the specified act. Section 3(1) of the TOLA states that something which becomes time barred between 20th March 20 to 31st March 21 is extended to 30th June 21. This is irrespective of the amendment carried out to the Income Tax Act. But in para 67, Supreme Court says TOLA will continue to apply to Income Tax Act after 1/4/21 if any action or proceeding specified under the substituted provisions of the Income Tax Act falls for completion between 20th March 20 and 31st March. Then in para 68, it states that for issuing a reassessment notice after 1st April 21, the department will have to look at two things: time limit under the new law and the extension provided by TOLA and also its notification. In para 72, it categorically held section 3(1) of TOLA overrides section 149, and the time limit to issue notices between 20th March 20 and 31st March 21 has been extended till 30th June 21. So Supreme Court says, in short, TOLA will apply even after the amendments brought out by Finance Act 21. First proviso limits issuance of notice till 6 years, but to that extent, one will have to construe extension till 30th June 21. This is a very important concept which Supreme Court has brought in, because based on this concept, Supreme Court has got a new concept of surviving period, which we shall be dealing with later on. Now, dealing with the time barring of AY 1314 and 1415. So 1314 got time barred on 31st March 20 under the old law, and it got time barred, 1415 got time barred on 31st March 21 under the old law. Notices were issued in July 22 till September 22. So department had to say that there is an extension from 31st March 2020, 31st March 2021 till July, September 22. They have broken this period into three parts. Firstly, they say up to 30th June 21, we could have issued notices under TOLA by virtue of extension. Then, from 4th May 22, Supreme Court gave us a new lease of life, a new time limits of furnishing material within 30 days, reply within 2 weeks. Therefore, from 4th May 22, I am governed by Ashish Agarwal. The only problem was, what will happen to the period between 1st July 21 till 3rd May 2022 before the Supreme Court judgment? It is then when all the courts had passed the judgments and the Supreme Court was seized with the issue. So Bombay High Court, in the case of New India Assurance, in the case of Godrej, has held that even if TOLA applies, extension applies till 30th June 2021. You have issued notices in July 22, August 22, September 22. There is no extension till July 22, August 22, and therefore all notices are time barred. To this, the department's reply was, up to 30th June, I am covered by TOLA. After 4th May, I am covered by Ashish Agarwal. And from 1st July 21 till 3rd May 2022, if you don't exclude this period, Ashish Agarwal will be frustrated. Judgment in case of Ashish Agarwal will be frustrated. To navigate this, the Supreme Court gave a very interesting finding. It referred to the provisions of section 148A into bracket B. It referred to section 149(1), third proviso, which is now fifth proviso, and then they gave their finding as under. Firstly, the Supreme Court held that under 148AB, two things was required to be done. A, you had to issue show cause notice, and B, you had to issue show cause notice along with material and information. So 148AB, issue show cause along with material and information. The Supreme Court judgment came on 4th May 2022. Supreme Court deemed the 148 notice to be a 148AB notice. Therefore, it should be stated that such notices have been stayed by the Supreme Court. Under 149(1), the third proviso, which is now the fifth proviso, period during which time is given to file reply and period of stay of 148AB notice, they have to be excluded for calculating the period of limitation. So once a 148AB notice is issued, if you have been given 2 weeks time to file reply, 2 weeks is to be excluded. And if this 148AB notice is stayed, then the period of stay has to be excluded for computing the period of limitation of 3 years and 10 years. Supreme Court held that Ashish Agarwal came with effect from 4th May 22. As a result, Ashish Agarwal directed the assessing officer to provide material within 30 days. prior to this direction by Ashish Agarwal, AO had no opportunity to give material to the SSEs. AO was deemed to be stopped from providing material to the SSEs. Since the notices were not accompanied by any material, therefore 148 notice, which is deemed to be a 148 AB notice, is not an effective show cause notice. A show cause notice will become effective only after the material is provided. Since the AO was deemed to be prohibited from issuing material, therefore it will amount to a stay as per the judgment of Ashish Agarwal. Since it is stayed, such period is to be excluded within the meaning of third proviso to section 149(1) of the Income Tax Act. Therefore, the Supreme Court excluded the period of 1st July 2021 till 4th May 2022, date of Ashish Agarwal, by applying third proviso to 149, by saying that this period is deemed to be stayed because of judgment of Ashish Agarwal and because AO was prohibited from providing any material to the SSC. It was inhibited from providing any material to the SSC. It is deemed to be effectively stayed from such date. Now, therefore, the Supreme Court came out with an interesting concept called as surviving period, which according to me was the most logical part of the entire judgment to give effect to its interpretation of A, TOLA overriding Finance Act 2021 and B, stay granted by Supreme Court. Now, what does the Supreme Court say? If I ignore the notifications issued under TOLA, or if I ignore the aspect of notices being issued under the old law, suppose if the assessing officer had, considering the extension of TOLA, directly issued notices under the new law, what was the last day to issue notice under the new law? The answer is 30th June 2021 as per the extension provided. If a show of 148 notice is issued to you under the old law, say for example on 1st May 2021, that is deemed to be a 148 AB notice. As per the notification, what is the last day to issue notice? 30th June 2021. So between 1st May 21, which is when the 148 notice has been issued, which is deemed to be a 148 AB notice, assessing officer had to complete the entire process till 30th June 2021. This period, it has been termed as surviving period, which means if your first notice, which is issued between 1st April 21 to 30th June 21, the first original 148 notice, which is now deemed to be a 148 AB notice by Ashish Agarwal. If, say, for example, it is issued on 1st June 21, that is deemed to be a show cause. What is the last day to issue notice under 148 as per the new law read with the notification? 30th June 2021. Therefore, assessing officer had 30 days time from 1st June 21 to 30th June 21 to complete the entire 148A process, irrespective of the time limits provided under 148AB, AD, etc. He had to issue notice up to 30th June 2021. This is the period, surviving period. Difference between 30th June 21 and the time when original 148 notices were issued to the assessor. Supreme Court says this is the time available to the assessing officer to issue notice under 148 after the judgment in case of Ashish Agarwal. And this time period has to be applied from the date assessee files his reply to the notice issued along with the material provided post Ashish Agarwal judgment. So if the pursuant to Ashish Agarwal judgment, if notice has been issued to the assessee on 20th May 2022 with the material, assessee has been asked to file reply within 2 weeks. Assessee files reply within 2 weeks. Say for example, he files reply on 10th June 2022. From 10th June 2022, AO will have to apply a surviving period, which we just computed. And if within the surviving period, 148 has been issued, it is valid, otherwise it is time barred. So this was the most logical conclusion which the Supreme Court has come. And they have also given an illustration in para 112. Para 112 says, let us take the instance of a notice issued on 1 May 2021 under the old regime. Because of the legal fiction, it is deemed to be a show cause notice. After accounting for all exclusions, assessing officer will have 61 days till 30th June 21 to issue a notice under 148 under the new regime. The time starts ticking for the assessing officer after receiving response of the assessee. If the assessee submits the response on 18 June 22, assessing officer will have 61 days from 18 June 22 to issue a reassessment notice under 148. Yes, if the assessing officer has issued notice under 148 up to 18 June 22, it's valid. Otherwise, it is invalid. So Supreme Court has not completely granted relief in the favor of the department. It has issued a new concept of surviving period to balance the rights of both the parties, which it itself has noted in the order. And this is the conclusion in para 114. The time during which the show cause notices were deemed to be stayed is from the date of issuance of deemed notice between 1st April 21 till the supply of relevant information and material by the assessing officer to the assessee in terms of direction issued by this court in Ashish Agarwal, and the period of 2 weeks allowed to the assessee to respond to show cause. Assessing officer will required to issue the reassessment notices within the time limit surviving. All notices issued beyond the surviving period are time barred and liable to be set aside. Therefore, not all notices of AY 1314 and 1415 are within time limit. You have to do a working. You have to find out what is the surviving period, and you have to find out whether notices have been issued within the surviving period or not. And I have tried to work out. This is a table which I have prepared. We will see the working, how it happens. Suppose the original notice is issued on 1st April 21. The second column is from the date of issue of original notice, what is the time available till 30th June 21? So if the notice is issued on 1st April 21, then till 30th June 21, assessing officer had 90 days to complete the 148A process. Now, after the Ashish Agarwal judgment, AO has provided material on 28th May. I have filed a reply on 15th June. And the 148 notice has been issued on 28th July. The surviving period is 90 days, difference between 30th June 21 and the date when the original notice is issued. Please calculate the difference between the new 148 notice, that is 28th July, and the date on which reply is filed, that is 15th June. That time gap is only 43 days. AO had 90 days to issue notice. He has issued notice within 43 days. It is not time barred. Take a case where notice has been issued on 15th May 21. From 15th May 21 till 30th June 21, the time gap is 46 days. You filed reply on 15 June 22. AO issued a notice on 28 July 22. The difference between 28 July 22 and 15 June 22 is 43 days. Since surviving period is 46 days, AO has issued notice within 43 days. It is not barred by limitation. Now, mind you, you don't have to see when the order under 148 AD has been passed. You have to see when the notice under 148 has been issued. Say 16th May was the first date. Then surviving period is 45 days. AO has issued notice within 43 days, therefore not time barred. But if you go to 19th May, surviving period is 42 days. AO has issued notice within 43 days, therefore it is time barred. Similarly, 1st June, 15th June, and 30th June, all notices issued on 30th June. Surviving period is only 1 day. And if the 148 notice is issued after 1 day from the date of filing reply, all notices are time barred. Similarly, 1st June 21 and 15 June 21, the respective working is provided. Surviving period is 29 days and 15 days, but the notice has been issued after 43 days. Therefore, all are time barred. So this is the working which one will have to do. Now, at this stage, let me draw attention to the importance of provision of material. Because Supreme Court has placed substantial importance on providing material along with the 148 AB show cause notice. To digress for a moment, all 148 AB notices not governed by Ashish Agarwal, but otherwise, where material has not been provided, would become without jurisdiction, because Supreme Court says providing material to an assessee along with 148 AB is one of the important requirement of 148 AB. Please see para 101. Under 148 AB, assessing officer has to comply with two requirements: issuance of show cause and supply of all relevant information which forms the basis of show cause notice. The supply of relevant material and information allows the assessee to respond to the show cause notice. The deemed notices were effectively incomplete because the other requirement of supplying the relevant material information. Supreme Court says in no uncertain terms, if 148 AB notice is not accompanied by the material or information relied upon, then it is deemed to be an ineffective notice, an incomplete notice, and ineffective notice. Let me digress here for a moment. Dehors Supreme Court Ashish Agarwal, AY 16, 17, 17, 18. Last day is 6 years, 31st March 23. AO issued you a show cause on 25th March 23, 148 AB. Not accompanied by any material. You filed a reply on 1st April 2023 that your show cause notice is not accompanied by any material. Please provide me a show cause. Then on 5th April, he issues you a notice with material. Then you can argue first notice is without any material. It is an ineffective and incomplete notice. Therefore, it is not a notice under 148 AB of the Act. The second notice, which is the notice which provides the material, is really the notice under 148 AB. Since the second notice has been issued beyond 6 years from the end of the relevant assessment year, proceedings are timed. So now I want to emphasize that providing material or information with show cause is very crucial, very important, and it can't be dispensed with. Without that, notice is ineffective, incomplete. Now let me come back to what the Supreme Court held. Then in para 2102, while creating the legal fiction in Ashish Agarwal, court was cognizant of the fact that AO were effectively inhibited from performing their responsibility until the requirement of supply of relevant material and information to assessees was fulfilled. This court lifted the inhibition by directing the assessing officers to supply the assessee with the relevant material and information relied upon by the revenue within 30 days. The Ashish Agarwal, this court directed assessing officer to provide relevant information and material within 30 days from the date of the order. Same thing in para 106 and in para 107. So court stated in the case of Ashish Agarwal, assessing officers were directed to provide material within 30 days from the date of issuance of 148 AB. Now, while calculating the period, surviving period, and to apply this period, I have two issues. Firstly, what if assessing officer has not provided the material within the 4 weeks as provided by Supreme Court in Ashish Agarwal? Not provided at all. In which case, the Supreme Court has held that the notice itself is not an effective 148 AB notice, it is bad in law. So all those cases where material is not provided and you have this argument that you have not provided material, everything is bad in law, according to me, the cases would survive and the cases would succeed on the ground that 148 AB notice has to be accompanied by material. It's very important to provide material, otherwise it's an ineffective or incomplete notice. Supreme Court directed you to provide material within 4 weeks or 30 days. You have not provided material, notices are bad in law. This takes care of a case where material has not been provided at all. Because we have seen many cases where assessing officer, despite directions of the Supreme Court, despite instructions, they have not provided complete material. Now, take a case where they have not provided material within 4 weeks as provided by Supreme Court in Ashish Agarwal. But when the assessee made a request, oh, you have not provided me the material, you provide me the material. And then they provided the material beyond 4 weeks. Then what is the impact? The answer should be same. You have not provided material within the 4 weeks time prescribed by Supreme Court. It was an extraordinary jurisdiction exercised by Supreme Court under Article 142. You were given extra time to provide the material. You have not provided the material within the time prescribed. All the notices are bad in law. But take a case where The assessing officer did not provide the material. You made a request, he provided the material, and he passed the order within the surviving period. Though according to me, all these notices where material has not been provided within 4 weeks should go, but the department can still argue, oh, what happened if I have not provided? I have subsequently provided and I have passed the order within the surviving period. There probably department may argue this, take this argument, but according to me, since the material is not provided, entire order should go. Now, the Supreme Court has given different findings in different paras. The Supreme Court excluded the period. Please see para 107 brought out on the screen. The total time that is excluded for computation of the limitation for deemed notices, time during which show cause were effectively stayed, that is from the date of issuance of deemed notice till the supply of material by the Supreme Court in terms of direction in Ashish Agarwal. Now, it's very important. It's not merely supply of material. Supply of material in terms of the directions in Ashish Agarwal. If you have not supplied the material in terms of the directions in Ashish Agarwal, which is 4 weeks, then beyond 4 weeks, nothing is to be stayed. You can't count your period again. And what is further to be excluded? 2 weeks allowed to the assessee to respond to show cause notice. Similarly, in 114G also it is replied that you have to exclude time between the original date of issuance of notice till 4 weeks from Ashish Agarwal and 2 weeks to file reply. Now, take a case where assessee has not filed a reply at all. Now, what will happen in those cases where assessee has not filed a reply at all? You have to compute the limitation period from the time 2 weeks are expiring. So, again, the same table. The first column remains same. What is the original notice? Time date. Second column remains same. What is the surviving period? Third column remains same. Material provided on. Fourth column is what is the time limit to provide material? 2nd June, which is 4 weeks from Ashish Agarwal, 4th May. What is the time limit to reply? 2 weeks. 2 weeks I have counted from, not from the date of providing actual material, but from the date when the Supreme Court directed them to provide material, which is from 2nd June. The last day to reply is 16th June. I don't file a reply. Because that is why the next column remains blank. Now the 148 notices have been issued on 28 July 22. Since the reply has not been filed, what you can exclude is only 4 weeks and 2 weeks, that is 6 weeks from 4th May. So up to 4th May, and thereafter after 4th May up to 6 weeks, which is 16 June 2022. Thereafter, you have to compute the surviving period. Notices have been issued on 28 July 22. What is the time gap between the notice date and the date of filing reply? 16 June and 28 July is 42 days. If this 42 days is within the surviving period, notices are not time barred. If it is beyond the surviving period, notices are time barred. So if you see 19th May, he had 42 days. He has issued notice within 42 days. Sorry, it should not be time barred. Here I have written yes, it should be no. But after 19th May, all notices will become time. So, in cases where replies have not been filed, you take into account 4 weeks and 2 weeks. What about a case where reply has been filed, but beyond the 2 weeks period? What will happen in cases where reply has been filed beyond the 2 weeks period? Now, here I have given a complete working. We'll go through the working slowly. The first 3 column, first 3, 4, 5 column remains same. First column is original notice. Second column is surviving period. Third column is material provided on. Time limit to provide material is 2nd June. Time limit to file reply is 16 June. Whereas the reply filed is 1st July. Reply is filed in all cases on 1st July. And notice under 148 has been issued on 14 July. Now, I have to compare the date of 148 notice with time provided by Ashish Agarwal, that is 14th August and 16th June, or I have to compare it with 148 notice date with the date on which reply is filed, that is 14th August and 1st July. If I compare it with the date on which I was supposed to file reply as per the Ashish Agarwal's judgment, then the time gap between 16 June 22 and 14th August 22 is 59 days. If you compare that with the surviving period in column number 2, you will find out that from the second date, 15th May onwards, everything is time barred. But if I compare 148 notice date with the date on which reply is actually filed, 1st July, then you will see that the time barring date would be from 18th May onwards, everything will be time barred. Here, I will just, though Supreme Court at 2 or 3 occasions have written that you have to compute 4 weeks and 2 weeks for the purpose of exclusion. But when it gives example of AY of 19th, when it gives examples of this 19th, 1st May, I'm sorry, para 112. Please see para 112 in your screen. Let us take the instance of notice issued on 1st May 21. Because of the legal fiction, deemed show cause notice will also come into effect from 1st May 21. After accounting for all the exclusions, AO will have 61 days, which is a surviving period. And then please see, this time starts ticking for the assessing officer after receiving the response of the assessee. In this instance, if the assessee submits the response on 18th June 22, 61 days will have to be calculated from 18 June 22. Now, many places they have written time from filing of reply. Many places they have written 4 weeks and 2 weeks. In this example, it is from the date of receipt of reply A. B. 18 June 22 in any case was beyond the 2 weeks prescribed by the Supreme Court. And therefore, one will have to probably take a view that you have to calculate and compare from the date on which you actually file a reply and not from the Supreme Court's date. But if you take this view, then people who have not filed reply are better off, because for them, you have to compute the period from the date of expiry of time limit period. So, one will have to wait for the compliances in this regard. One will have to wait for the instructions in this regard. Supreme Court is saying both things. We'll have to wait and see what courts are interpreting. So, insofar as 1314 and 1415 is concerned, I am through. This is how you will compute the surviving period, and this is how you will find out the limitation issue. Now, coming to AY 1516 new law. AY 1516 new law. After Ashish Agarwal's judgment, what is the time barring date? In para 19G and in the table above para 19G, the Supreme Court writes that revenue concedes that for assessment year 1516, all notices issued on or after 1st April 21 will have to be dropped, as they will not fall for completion during the period prescribed under TOLA. So, if your assessment year is 1516 post Ashish Agarwal, then it has to be dropped. In effect, hexaway to the above effect has been approved. So, AY 1516, probably all notices pursuant to Ashish Agarwal issued in July 22 till September 22 will have to be dropped. This is a concession given by the department. But take a case where Ashish Agarwal does not apply and department has issued notice on or after 31st March 22, because the 6 years as per first proviso to 149(1) expires on 31st March 22. So, they have issued notice on 31st March 22 or 30th March 22. Even those notices have to be dropped, because that is my question. And the reason behind that question is because the department concedes that all notices issued on or after 1st April 21 will have to be dropped. So, can the SSC argue that department has considered after 1st April 21 you cannot issue any notice? The answer has to be no, because this para 19G deals with the case where Ashish Agarwal has applied. Court says that AY 1516 TOLA does not apply. Since TOLA did not apply, notices from 1st April 21 to 30th June 21 under the old law itself are bad in law. Further, 30th June was not the time limit. Therefore, there will be no extension. And therefore, all the consequential effect of Ashish Agarwal, etc. will not apply. And therefore, all those notices issued in July to September 22 have been dropped. That was the issue raised before the court. And if it is issued otherwise within the time limit under the new law as per 149(1)(b) read with first proviso, then they cannot be dropped. Here, probably one of the argument which an assessee can take is, in the case of Hexaware and Godrej, the Bombay High Court has held that as per the first proviso, you have to issue notice within 6 years from the end of the assessment year. Therefore, last day is 31st March 22. If you issue show cause on 30th March 22, giving me 10 days to file reply, and ultimately you issue 148 notice on 11th April 22, those notices are time barred because first proviso shall prevail over fifth proviso. First proviso says last date under old law, 31st March 22, that will prevail over exclusion prescribed under fifth and sixth proviso. Coming to AY 1213, the court has given an example that AY 1213 becomes time barred on 31st March 19, and therefore, as per the first proviso, it has become time barred. Now, really, this will have an impact on notices issued after 31st March 22, before 31st March 23, in a search case, because first proviso was amended by Finance Act 2022 with retrospective effect from 1/4/21, and after amending the 149(1) proviso, it stated that you don't only have to see the time limit under old 149(1)(b), you also have to see the time limit under old 153A and 153C. Now, so Supreme Court has held that AY 1213 is time barred. One can argue AY 1213 issued, whether search, not search, everything is time barred. Supreme Court holds so. But probably the department will argue that Supreme Court was not seized with the controversy and the amendment brought in by Finance Act 22, and therefore it may not apply. The Supreme Court was also dealing with the controversy of notices issued between 1/4/20. I'm sorry, this time has to change. It is between 1/4/2020 to 31st March 21. 1/4/2020 to 31st March 2021 under the old law for assessment year 15/16. Now, assessment year 15/16 under the old law, time limits were 4 years and 6 years. 4 years expired on 31st March 2020. When they issue notice after 31st March 2020, that is with effect from 1/4/2020 to 31st March 2021, some of the officers, not all, but some of the officers took a view that this 4 years period have been extended. And therefore, when I issue a notice between 1/4/2020 to 31st March 2021, I am issuing a notice within 4 years period, and I will take approval of Joint Commissioner and Additional Commissioner. Bombay High Court, JM Financial, the Orissa High Court, the other high courts, the other judgments of the Bombay High Court and Orissa High Court have taken a view that TOLA does not apply to 15/16 and subsequent assessment years. TOLA in any case does not apply to approval. Since notice has been issued beyond 4 years, approval has to be of principal commissioner and commissioner under the old law. We are concerned with old law right now, AY 15/16. Supreme Court held that in case of 151 of the old regime, the test is the time limit of 4 years from the end of the assessment years falls between 20th March 20 and 31st March 21. Then the specified authority under 151(2) has time till 31st March 21 to grant approval. Supreme Court reversed the finding of Bombay High Court. Supreme Court held that a joint commissioner and additional commissioner is the appropriate authority to issue approval under the old law for AY 15/16 between 1/4/2020 to 31st March 2021. Now, this has a very big fallout. Number of notices were issued between 1/4/2020 till 31st March 2021 under the old law for AY 15/16 after considering it to be a case beyond 4 years with the approval of principal commissioner or commissioner. All those notices are bad in law because of this Supreme Court judgment, which states that all those notices had to be issued with the prior approval of joint commissioner and additional commissioner and not with the approval of principal commissioner or commissioner. Somebody will ask me a question, sir, if it is issued with the approval of principal commissioner, he is a superior authority, then he can grant approval. The Bombay High Court in case of Ghanshyam Khabrani has held that if law requires something to be done in a particular manner, it has to be done in that manner. If Joint Commissioner has to grant approval, he has to grant approval. It can't be granted by Principal Commissioner because both the authorities have been separately defined. Therefore, all notices AY 1516 between 1st April 2020 to 31st March 2021 issued with the approval of Principal Commissioner are bad in law, and the same finding has come in Supreme Court's order also. Supreme Court has given at 3-4 places findings that approval has to be of the appropriate authority. Appropriate authority is specified in the section. Appropriate authority has been defined in section 2. If somebody has granted approval who is not an appropriate authority, then it is bad in law. There are these 4 findings of the Supreme Court. All AY 1516 cases, old law between 1/4/2020 to 31st March 2021. Wherever your case is before the appellate authority, High Court, wherever, you can take this argument. It's now covered by Supreme Court judgment in case of Rajiv Bansal. Some general findings before the Supreme Court, by the Supreme Court, which are also relevant because Supreme Court gave various findings, gave entire thesis on Ashish on the issue of reassessment, issue of assessment, machinery provision, interpretation of statute. Some very briefly, some of the findings of the court. Court holds Article 265 applies to not only charging section but also the machinery provision as well as the assessment provision, which means if the assessment procedures are not in accordance with law, then as per Article 265, entire assessment is bad in law. They also hold in para 24, what do you mean by a process of assessment? Process of assessment involves computation of income, determination of tax payable, and procedure for collecting or recovering tax. This is the process of assessment. Now, why I have highlighted this para 24 of the Supreme Court is because right now a controversy is going on before the High Courts and Supreme Court to the effect that under 144C1, AO has to pass a draft order in case of an eligible assessee. If along with the draft order, AO has issued a notice of demand and a penalty show cause notice, whether it can be considered as a draft order or it's a final order. Karnataka High Court has taken away that it's a final order, and since you have not followed 144C1, entire thing has to go. Supreme Court in Rajiv Bansal para 24 will help you in arguing that since you issued a notice of demand, you have completed the process of assessment, and therefore you have not followed 144C1, entire thing has to go. Para 26, Supreme Court holds assessment is a vested right. Once an assessment is concluded, it's a vested right. It cannot be disturbed. It cannot be affected retrospectively unless the law is intended to be retrospective in nature. This becomes a very crucial because once an assessment is completed based on the law which was existing at the time of completion of assessment, thereafter there is an amendment, either prospective or retrospective. Courts can take a view that since the assessment is completed, assessee acquired a vested right, you cannot tinker with that by way of a subsequent amendment. A very crucial finding, and it will disturb a lot of cases, is para 26. In para 26, Supreme Court holds reassessment is nothing but a fresh assessment. Effect of reopening is to vacate or set aside the order of assessment and to substitute in its place the order of reassessment. This is going to create a havoc. It's a finding by Supreme Court, a 3-judge bench of Supreme Court. I will give an example. If your assessment order is completed, AO has made a 1 crore addition. You are in appeal before CIT appeal. Subsequently, reassessment order is passed and he makes some other addition but does not make the addition made in the original assessment order. Once the reassessment order is passed, first assessment order is vacated, set aside, all those additions goes, your appeal becomes infructuous. Second case, you are in appeal before CIT appeal against the original assessment order, you succeed, department is now in appeal before the tribunal. They make a reassessment. In the reassessment, they cannot make the same addition. They have not made the same addition. They make some other addition. Once the reassessment order is passed, the first order is vacated, set aside, and replaced by the order of reassessment. As a result, department's appeal before the tribunal will become infructuous because that order no longer survives in the eyes of law by virtue of para 26 of the Supreme Court judgment in case of Rajiv Agarwal. Para 27, sanction is an administrative act, they have reiterated, but para 73, para 76 and para 27, they have stated that sanction is an important safeguard from mechanical exercise of reopening. It's very crucial. It's a very crucial finding given by the Supreme Court that sanction cannot be mechanical in nature. It's a very important safeguard, and they have given at three places they have given finding. Para 73, they hold that purpose behind this procedural check is to save the assessees from harassment resulting from mechanical reopening of assessment. Grant of sanction is a precondition before assuming jurisdiction. So sanction cannot be taken lightly. If you can show sanction is mechanical in nature, everything has to fall flat. Reassessment proceeding is bad in law. There cannot be any estoppel or waiver against a jurisdictional requirement. If a statutory authority lacks jurisdiction, or if it does not fulfill the preliminary conditions laid down under statute, then it is without jurisdiction. There cannot be any waiver of statutory requirement or the provision that goes to the root of the jurisdiction. An order passed without jurisdiction is a nullity. Any consequential order passed or action taken will also be invalid and without jurisdiction. So you have not raised any objection in the course of assessment proceeding. No difficulty. You can raise it in the appellate proceeding or before the writ court. An order is passed. You don't raise any objection. Assessment order is passed. You can challenge the assessment order on the ground that since the reopening is invalid, therefore subsequent assessment is also invalid. A department cannot argue, take the argument of estoppel or waiver. They also give an incidental filing, charging section, strict interpretation, machinery provision, liberal interpretation, and section 147 to 151 are machinery provision. As we discussed, show cause notice is not effective if not accompanied by material. We also discussed what are the effect of this finding. All show cause notices under 148AB, which are not accompanied by any material, are not valid show cause notices. Valid show cause notice would be a notice which is accompanied by material, and you have to count the period of limitation from that date. This becomes very crucial. Supreme Court also holds nothing unjust if an assessee escapes the law because the charging section fails to provide, that is a settled law. And they have also given certain finding on repeal of the law or substitution, repeal by way of substitution. These certain important findings have been given. Now, what now? What is one supposed to do? Firstly, the Supreme Court has also passed a consequential order on 3rd October. And the consequential order says the assessing officer will dispose of the objections in terms of the law laid down by this court. Thereafter, the assessees who are aggrieved will be at liberty to pursue all rights and remedies in accordance with law, save and except for the issues which have been concluded by this judgment. Supreme Court only concludes on 3 or 4 issues. A. Ashish Agarwal applies to Pan India. B. Who has to grant approval. C. Time barring considering TOLA. Supreme Court deals with no other issue. High courts have allowed the assessees writ on these 2 issues. Since High Court has not gone into other issues, you must have taken other challenges. Supreme Court says, firstly, assessing officer will pass an order disposing objections in light of what the Supreme Court has held. So probably, after the Supreme Court order, assessing officer will now pass an order giving effect to Supreme Court judgment. In light of this Supreme Court order, I personally feel we will have instruction number 1 of 2024, which will lay down what is their interpretation of the Supreme Court judgment. B. Will the Supreme Court judgment apply Pan India? I'm sorry, firstly, coming again back to the first issue. After they pass the consequential order, you can challenge that consequential order wherever you want to challenge, including a writ court on other arguments. Suppose if it falls within the surviving period, then you lost the time barring argument. You can challenge on the other issues, a change of opinion or material not provided, parcel hearing not provided, etc. Suppose you feel, oh, I'm not following the surviving period. AO takes a view, you follow the surviving period. Again, you can challenge before the appellate court or before the writ court. So these are the sequitur. So not everything has been lost. Probably 15, 16, 16, 17, 17, 18 goes. 15, 16 department considered. 16, 17, 17, 18 our view that approval is bad in law, which has been upheld by Supreme Court. 13, 14, 14, 15 cases which are beyond surviving period goes. you are left with cases which fall within the surviving period. For those cases, you have other arguments to be taken, and you can take other arguments, including the argument of hexaware that notices are issued by jurisdictional assessing officer and not by faceless assessing officer. That still remains open. Now, this also one of the corollary argument would be, who is supposed to pass the consequential order? Will it be passed by the assessing officer, jurisdictional, or the faceless assessing officer? Time will only tell what will be done by the department. Probably it will be done by jurisdictional assessing officer. They'll come out with an instruction for that. 2. Will it apply pan India? So, what is the application of the judgment of Supreme Court in Rajiv Bansal? Will it apply to all cases? My personal reading is, this judgment of Ashish Agarwal is not pan India. This judgment of Rajiv Bansal is not pan India. They have not invoked Article 142, and therefore it will only apply to cases which have been disposed of by Supreme Court. Therefore, the sequitur to this will be, what will happen if I have succeeded before the High Court? If you have succeeded before the High Court, wait for your case to be taken to Supreme Court and for the Supreme Court to reverse it, and then the EO will pass a consequential order, and then you have to take consequential step. Should I worry at this stage? The answer is no. If your matter is not covered, not one of the matters listed before the Supreme Court, wait for your turn to go before the Supreme Court, and wait for the Supreme Court to pass appropriate order in light of what the Supreme Court has held here. Three, there may be chances that your case may not be taken to Supreme Court at all. Then everything is done. Your case is disposed of by the High Court. Department subsequently files an SLP before the Supreme Court. You can argue before the Supreme Court that, okay, send the matter back to the High Court with the directions given by Supreme Court so that I can take the other arguments. If a Supreme Court bench is ready to send the matter back to the High Court to decide in accordance with the Rajiv Bansal judgment, all your arguments are open. You can argue everything before the High Court. But if the Supreme Court bench subsequently holds, no, AO to pass a subsequent order, and then your all rights and contentions open, then you have to follow what has to be done, as in case of Rajiv. What if writ has been filed and is already pending before the High Court? The High Court, therefore, will now go through the concept of surviving period. Probably the High Courts may ask the department to file an affidavit in respect of this concept of surviving period. Assessee may also file an affidavit to show what is the surviving period, whether it falls within the surviving period or beyond surviving period. Once that is done, if it is beyond the surviving period, High Court may allow your writ. If it is within the surviving period, you may have to argue your writ petition on the other grounds. What if we are in appeal and no writ is filed? What if you are in appeal and no writ is filed? If you are not filed any writ petition, your appeal is pending either before the CIT appeal or ITAT, or it may go to the High Court. In which case, you may rely upon the Supreme Court decisions and argue it's beyond the surviving period. If the court agrees, is willing to go into the concept and the calculation of surviving period and want to give you relief, you're through. If not, they may say, oh, we are sending this back to the assessing officer to pass order disposing objections in light of the Supreme Court judgment. They may say so. So, if you are in appeal, if it is falling within the surviving period, you have to drop the argument of limitation. If it falls beyond the surviving period, you may take the argument, go ready with a chart, calculation, working, show the court, oh, you're through because of the surviving period concept. Please allow my appeal covered by Rajiv Bansal. Court may allow it, or court may send it back to the assessing officer for this limited extent. Most important, Siemens was the case where Bombay High Court held that you cannot reopen under the new law based on change of opinion. Siemens was before the Supreme Court. I am told that in the Siemens SLP, one of the ground was change of opinion concept does not apply. Supreme Court has not given any finding on the concept of change of opinion. At the same time, Siemens judgment has been modified to this limited extent. In my view, since the civil appeal has been modified to this limited extent, according to me, change of opinion concept has been accepted by Supreme Court to be a valid reason to strike down a 148 notice even under the new law. So this is, according to me, the consequence of the Supreme Court judgment. We have to still apply our mind onto proper reading of the Supreme Court judgment. There may be various other issues. This is my prima facie view. We have to wait for the department's view on Supreme Court judgment. We have to wait for their instruction, and then we'll come across of the clear position. At this stage, probably nothing is that clear. I think many people are online. If you're part of any association or any organization, including CTC, there have been 2 rounds of litigation till date. I will request the association or organization to make a request to the Government of India, CBDT, Ministry of Finance, that to extend the VSV scheme to all cases which are pending before the writ court or Supreme Court, or cases which have been disposed of. This, in my view, will be a very important step by the department if they allow an assessee to opt for VSV for Ashish Agarwal cases. Naturally, if you have filed an appeal, you are before the CIT appeal, you are before the tribunal, you are an eligible assessee, you can go and file, close your case under Vivad Se Vishwas. But cases which have not gone to the appellate authorities, which are pending before the various high courts or Supreme Court, in those cases, in my opinion, a request should be made to the government to make the VSV scheme applicable to all these cases. If VSV scheme is applicable, probably we can save the 3rd round of litigation in those cases where the assessee thinks that they don't have a great case, and or where they think the tax effect is not that great. Let us pay the tax, forget interest penalty, and we can get the matter closed. Because one should appreciate we are at the 3rd round. The judgment of the Supreme Court in Rajiv Bansal, somebody has to interpret the judgment, somebody has to apply the judgment, and it's not that 2 + 2 is equal to 4. You have to still interpret, apply, and come to some conclusion which will result into a litigation. One can avoid. Probably VSV can be extended, representation can be made to put an end to all these notices. Assessee would be happy to pay 30% and surcharge, not pay interest, not pay penalty, and not pay litigation fees, including the counsel fees, and close the matter. So I think, thank you. That is from my side. Maybe I was a bit fast, but please excuse me.
Thank you, Dharan. Thank you very, very much. On behalf of all the participants and on behalf of CTC, I extend a sincere gratitude to you for taking up this topic and sharing your valuable insights on the TOLA 148 order. I'm sure you have cracked and given your expertise and your perspectives, which have deeply contributed to our thinking, and we will start thinking from this point as well. On behalf of CTC, once again, I thank you for taking this up at such a short notice.
You want to take me the questions? I can
Yes.
take the questions quickly.
So,
I'll take the Q&A first. So I think
Okay.
I'll take it up, Viraj and Kirti. I'll just read and I'll answer them.
Okay. Okay.
Mr. Prasann Joshi, whether in case where assessment orders were passed before Supreme Court in Ashish Agarwal, will it be rectifiable under 154? Sir, I've answered. May or may not be. We have to wait for the Supreme Court to reverse the Delhi High Court. If Delhi High Court is accepted, then probably it may not apply to cases which have been disposed of prior to Ashish Agarwal. Mr. Kamasastri, for AY 13, 14, 14, 15, his notice is not challenged before the High Court and now proceeded to pass an order under 147 in March 2022. No further notices proceedings in terms of Ashish Agarwal initiated. Oh, if no notices have been initiated pursuant to Ashish Agarwal, then sir, your case is closed. You can rely upon Ashish Agarwal, you can rely upon Rajiv Bansal, you can argue notices under section 148 are bad in law since issued under the old law despite the new law being applicable as held by the Supreme Court. And if the department relies on Ashish Agarwal, then they have missed that bus of issuing notices and providing material within 30 days time from the Ashish Agarwal judgment. That's completely gone case. Jao Fao, I've already answered. AY 1819 case with the approval of PCIT is invalid. There is Mr. Vinay Kavadia is asking if any hint from Rajiv Bansal at 148 notice issued in April 22 for AY 1819. No, Ashish Agarwal, the Rajiv Bansal case was not dealing with this issue. Nothing in our validity of 148 notice for AY 1516 issued in April 2022. I have answered that. Could you please explain by way of an example why did the ASG concede AY 1516? Sir, ASG is speaking on 14. You can ask him. Extension of time limit under any law. I'm sorry, he is referred to some. Mr. Prasan Joshi is referred to MA 665 of 2021. This probably appears to be suo motu judgment of the Supreme Court wherein the time limit has been extended. Sir, those judgment would not apply to a notice to be issued by an authority because TOLA specifically covers that. Mr. Piyush Bafna, can Supreme Court create a fiction through its judgment invoking its power under Article 142 in light of recent Supreme Court Constitution Bench judgment in the case of High Court Bar Association Allahabad, which held that 142 doesn't empower court to ignore substantive right of litigant? Whether this argument was taken before Supreme Court, as nowhere judgment speaks about its power under Article 1. No, sir. There's a detailed discussion on Article 142 by the Supreme Court, and that you will find at page 91 to 96 of the judgment. Supreme Court has discussed various judgments dealing with power of Supreme Court on Article 142, and they have stated that it is to do justice, and while invoking Article 142, they can deviate from the statutory provisions, not from the constitutional provisions, but from the statutory provisions. So they can deviate. In any case, it's a judgment of Supreme Court, 3 judge. Today, there's no point discussing this issue. As per para 112, surviving period will start ticking in. If no reply is given by SSC, how will the time start ticking in? I think I have already replied. Are the limitation chart given applicable only for AY 13, 14 and 14, 15 and not thereafter? Yes, because 15, 16, 16, 17, 17, 18 we have already discussed. That those will not survive. Of course, I'm sorry. I am left with AY 16, 17 limitation issue. Viraj, if you permit, 5 minutes on that.
Yeah, sure.
Because I have just left that thing. I had supposed to take it after 13, 14 time barring date, but I missed that. And thank you for reminding me. I'll just start my screen to that extent. Yes. On the limitation issue, of course, Mr. Venkatraman stated that if we are invoking 6 years for AY 13, 14 and 14, 15, if less than 50 lakhs, we will close it. But similar promise was not given for AY 16, 17 and 17, 18. Moreover, Supreme Court in para 69 has held that for assessment year 17, 18, 3 years period on 31st March 21, expiry of time fell within the time period contemplated in TOLA. Resultantly, revenue had time till 30th June 21 to issue a reassessment notice for AY 17-18 under 149(1)(a). This is the only finding by Supreme Court in para 69, that if they issued notice till 30th June 21, it could have been done under 149(1)(a). If it is done beyond 30th June 21, then it has to be under 149(1)(b). That is my personal take. As a result, all notices for AY 16, 17, 17, 18 issued in July to September 2022, probably less than 50 lakhs. You can argue I am covered by Delhi High Court Ganesh Dar Khanna and para 16 of Rajiv Bansal. Without prejudice, assuming for a moment you apply the surviving period concept for AY 16, 17 and 17, 18, without prejudice, I am not strictly applying it, but if you apply it, then if it is issued within the surviving period, then it is within 3 years. If it is issued beyond the surviving period, it is beyond 3 years. That can be the worst case scenario from SSC's perspective. If it is issued within surviving period for AY 16, 17, 17, 18, then it may be constituted to be under 149(1)(a). It may be. But if it is issued beyond the surviving period, it may not be constituted to be within 149(1)(a). It is beyond 3 years. But according to me, para 69 of the Supreme Court is categorical. Department had time till 30th June 21 to issue notice under 149(1)(a). Since after 30th June 21, the department was not barred from issuing notices under the new law because they still had time going beyond 3 years up to 6 years. That is why I think Supreme Court has not given this finding in its order that AY 16, 17, 17, 18 notices issued in July 22 to September 22 are within 3 years. Probably this appears to be my logic. So I think 16, 17, 17, 18, Ganesh Das Khanna has been upheld by the Supreme Court. So Mr. Udit Bhatia, I think I have answered your question. Concession is only respect of 4-year case under old law. This is because for 6 years the time still remains. Some anonymous attendee. No, sir. The concession is very categorical. After 1st April 21, under new law, TOLA does not apply. Therefore, they could not have banked upon TOLA. Insofar as old law is concerned, court was not concerned with the limitation issue. Court was only concerned with the approval issue. And okay, the next question. Will the condition of no failure on the part of the taxpayer as per the old law still apply to notice issued under AY 13, 14, 14, 15? Mr. Nemin Shah, this issue is not subject matter of consideration by the Supreme Court. Somebody may imply that Supreme Court has dealt with everything and therefore you cannot argue this. My humble opinion is Supreme Court has not dealt with this argument that for AY 13, 14 and 14, 15, 4 years have already expired. If there is a prior assessment and if you have already disclosed everything, then the proceedings have become time barred. Since it has become time barred, therefore you cannot apply the extended period under TOLA. You can still very well argue this. In fact, to this extent is a judgment of the Karnataka High Court in case of Azim Premji. Identical issue, Karnataka High Court, Azim Premji. Abhilash, is the theory, travel back theory still valid? If yes, then for AY 16, 17, 17, 18 approval from PCIT will be valid. I think I've already answered this. In case of 90 days of surviving period, then if the 148 AD order is passed after 1 month from the end of the month and 148 notice is issued within the surviving period, whether it will be valid, I have already answered that. We have done the calculation. In reassessment, disallowances in the original assessment are reconfirmed. If the revenue is still contesting the appellate judgment in reassessment, disallowances in the original assessments are reconfirmed. If the revenue is still contesting the appellate judgment in favor of the SSC, sir, I am not able to make out from the question. Whether Rajiv Bansal is a ratio decidendi for many legal principles reiterated and enunciated in paragraph 21 to 43, or they are to be considered as passing references. Yes, Mr. Bhafna, an excellent question. 2 answers. A, the court says that we are giving our findings based on the legal principles brought out earlier. So one may argue this is clearly not a passing reference. 2, Supreme Court, while giving principles, has relied upon various judgments. So you can't say it is a passing reference. And 3, in any case, even an arbiter by Supreme Court is binding on the lower authorities under Article 141 of the Constitution of India. Will the AO obliged to issue a show cause or at least a personal hearing while giving effect to Supreme Court order? Can we take the objection to challenge the ordering effect to the Rajiv Bansal of the AO if applicable? A, they are not supposed to give you hearing. They are supposed to pass an order disposing objection. And therefore, you will not be given any hearing. But once the order disposing objection is passed, you can challenge that in appropriate proceedings. Ketan bhai, monetary limit will be helpful for the matter before Supreme Court if department goes to Supreme Court. Department circulars say that monetary limit will not apply to writ petition matters. A. Therefore, the department argues that it will not apply. But I have come across many Supreme Court decisions where department has withdrawn the SLP against the writ orders on the ground of tax effect. So we can rely on that to argue that tax effect is less. Even if it is by way of a writ petition, you have to withdraw. AO has issued notice for assessment on the basis of 148 notice issued without following the procedures under 148A. Also is not giving reasons for reopening the assessment. Assessment is 1415. Are the proceedings valid? They are clearly not valid. They are supposed to give you material, etc. Under which para department considered for AY 1516? I think para 18 E or F. You can refer to my presentation. It will be uploaded. Notice was for above 50 lakhs, but addition was for below 50 lakhs. Is it valid? Beyond 3 years case, I think you must be before the appellate authority. You can argue it's not valid because ultimately the escapement of income is less than 50 lakhs. This issue is still live. No court has taken a decision. PY 1617, concept of failure will not apply because 4 years have not expired. In case appeal is pending before CIT appeal, are we required to file objections before the are we entitled to or required to file objections before? No. If your case is pending before CIT appeal, file a submission before CIT appeal. If you are covered by Supreme Court judgment, if you are not covered by Supreme Court judgment, the concept of surviving period or approval, etc., then you may make your case on the other arguments. This is the chat box. Okay. So mostly I think they are saying give me your PPT, and I think the PPT will be uploaded. Mr. Kalpesh Doshi. Notice under old law. Notice under for revised 1718 old law. I think I've already answered. Some SG has written that if Supreme Court has cost and only set aside to that extent, will IT department have to go back to the High Courts to modify their judgments? No, in fact, Supreme Court has allowed the departments SLP, and we have to approach the High Court if the assessing officer's order giving effect to Supreme Court order is not what we desire it to be, or if we feel it is not in accordance with Supreme Court judgment. Ketan Bhai, I believe VSC is applicable in cases where appeal is pending before High Court or Supreme Court. So two things. A, it's not applicable in case of writ petitions. We were in writ petitions. B, suppose if the High Courts have passed the order before 23rd July, I think, which is the date specified for VSV, then probably you have a difficulty. Because this time the VSV scheme does not even specify cases where time limit to file an appeal or petition or SLP has not expired. So to that extent, there is this problem. And since you are the committee chairman of LNR committee, I request you to make a representation to cover these cases. Probably it will be helpful to a number of assessees. No further notice in persons of Ashish Agarwal was issued by AO and currently pending in appeal. I think I have discussed that. Yeah, okay. Thank you so much for a very patient hearing. I think I am done.
Thank you, Dharan. Thanks a lot.
Yeah, thank you, Dharan. I think we'll all agree it was a detailed session. I think lot of queries and lot of resolutions have come out of.
I don't think resolutions have come. Let
It
there
is
be.
never ending.
Thank you so much. Thank you.
Yeah, thank you.
Thanks, everyone.
Thank you everyone.